Thank y'all for being here. Subcommittee will come to order. Welcome, everyone. You know, employers are on the front lines of ensuring legal workforce, and it's a battle for these employers. Consider for a moment that due to our broken immigration enforcement system, the Pew Hispanic Center estimates there are over 8 million illegal workers in this country. With unemployment around 9%, these illegal workers often compete with lawful citizens for much-needed jobs. Today's hearing will examine the employment verification systems available for employers' use, including E-Verify, the largely voluntary system, jointly administered by Social Security and Homeland Security. Since our last hearing on this subject nearly 3 years ago, the use of E-Verify has expanded, and today there are over 250,000 employers. That's about 4% is all of all U.S. employers registered to use the system. In addition, the use of E-Verify has been mandated in 3 states and for the federal government and certain federal contractors and subcontractors. Social Security is an integral partner in E-Verify because it has the only database that can confirm citizenship. I want to make clear, however, I'm very uncomfortable that Homeland Security is checking on U.S. citizens. That said, Social Security and Homeland Security have, to their credit, worked together to make E-Verify more workable and more accurate. However, as we shall hear shortly from the Government Accountability Office, E-Verify remains vulnerable to identity theft and to employer fraud. As my Texas colleague and chairman of the Judiciary Committee, Lamar Smith, has said, perhaps the most valid criticism of E-Verify is the identity theft loophole, and I couldn't agree more. If an employee presents a stolen Social Security number and fraudulent photo ID, E-Verify will erroneously indicate that the individual is authorized to work. The employer has been duped, and an innocent American may face years of financial and legal woe because his identity has been stolen. To build on the successes of E-Verify while making needed adjustments to ensure successful implementation, last Congress I introduced H.R. 5515, the New Employee Verification Act, or NEVA. NEVA would achieve 3 important goals. 1, ensure a workable legal workforce, safeguard workers' identities, and protect Social Security. It's true that Congress gave the American people an employment verification system that works while protecting Social Security's ability to serve the public. I would hope that this is one immigration-related issue where both sides could find common ground. As we move forward, we must carefully consider the potential burdens to Social Security and, most importantly, to workers and employers struggling in these trying times to get Americans working again. I appreciate all y'all being here. I think that we're going to have a good panel today, and I thank you for joining us. I look forward to hearing our expert testimony from all of you. And I now recognize my friend and the ranking member, Javier Becerra, for his opening remarks.
Mr. Chairman, thank you for calling today's hearing to examine the impact of electronic employment verification, eligibility verification systems, and the impact it has on the Social Security Administration and on our workers in the United States. The Social Security Administration has played a critical role in the verification of our workforce since 1997, when the basic pilot program began, which is now, of course, known as E-Verify. Today, the majority of employees who are checked through E-Verify are cleared fairly quickly. However, some workers are not. Our witnesses today will describe what happens to a worker when they receive a tentative non-confirmation that the information submitted by their employer doesn't match information contained on government databases. A recent Government Accountability Office report concluded that individuals often face significant difficulties in resolving non-confirmations. This is not a trivial matter because the inability to resolve an erroneous non-confirmation can lead to the loss of a job. In addition, I am deeply troubled to learn that many employers do not comply with E-Verify program rules designed to prevent discrimination or abuse of the system. In this downturn economy, one job lost due to mechanical or technical error or employer noncompliance with E-Verify requirements is one job lost too many. Mr. Chairman, at this time, I'd like to submit into the record the stories of Americans who have suffered greatly from problems with E-Verify. These illustrate the kinds of challenges U.S. citizens and legally authorized workers face in keeping their jobs.
Without objection.
Thank you. Many would like to expand the E-Verify system, but we should not do so unless we first address the kinds of problems with the existing system that is identified in today's hearing. In addition, to be able to meet the needs of this growing program, more resources have to be dedicated to it. While some have proposed making E-Verify a permanent mandatory program, the Congressional Budget Office has estimated that this would cost the taxpayers nearly $18 billion over the next 10 years. As we work forward and make progress in trying to improve this program, the ultimate solution to what we're trying to address through E-Verify is to reform our broken immigration system. In places like Arizona, where E-Verify is mandatory, some employers have resorted to paying their employees under the table or have simply not just stopped complying with the program. The state has also seen a loss of income tax revenue, confirming predictions that mandatory E-Verify in the absence of immigration reform simply drives employers into the underground economy. Chairman Johnson and I look forward to working together to jointly improve our electronic employment verification system, and I thank you for calling today's hearing.
Thank you, sir. Today we're joined by 5 witnesses. Our first witness will be Richard Stana, Director, Homeland Security and Justice, United States Government Accountability Office. Next is Mariana LaCanfora, is that correct?
Correct.
Assistant Deputy Commissioner, Office of Retirement and Disability Policy, Social Security Administration. Next is Tyler Moran, Policy Director, National Immigration Law Center. Next is Anna Antone, PhD Professor, Department of Computer Science, College of Engineering, North Carolina State University, on behalf of the Association for Computing Machinery. And finally, Austin Fragaman, Chairman of the Board of Directors of the American Council on International Personnel, on behalf of the HR Initiative for a Legal Workforce. I welcome all of you, and we look forward to hearing your testimony. Each witness will have 5 minutes, and your written statements will be made part of the record in the event you run over a little. So I thank you, and I welcome you, and thank you, Mr. Stana. I think you're welcome. You're recognized for 5 minutes.
Okay, thank you, Mr. Chairman. Thank you, Mr. Becerra and members of the subcommittee. I'm pleased to be here today to discuss the results of our work on E-Verify, which is a voluntary program that can be used to verify the work authorization of newly hired employees. I'd like to discuss 3 points from our report, and then later I'd like to get into briefly some issues that may be of interest to the subcommittee on how it would affect the Social Security Administration. First, let's discuss the TNCs, the tentative non-confirmations. Here, USCIS has substantially reduced the number of TNCs from about 8% of all queries just a few years ago to 2.6% in fiscal year 09, which was the subject of our study, down to 1.7% last year. So that's moving in the right direction. This was done by expanding the number of databases that are queried. They now look at naturalization databases, and they look at passport data, and also by screening for common data entry errors like transpositions or European date format that can be easily fixed. But erroneous TNCs continue to occur when employee names are misspelled or they're transposed, or people with multiple surnames use different surnames in one document than they use in another document, and thus it triggers a TNC. Erroneous final non-confirmations can occur when SSA field office staff do not update the EV STAR system, which is an information system on workers who receive SSA TNCs, but SSA is addressing this issue, so we hope that this will be resolved soon.
Mr. Tanner, can we ask that you, instead of using the acronyms, mention the names of these programs, because a lot of folks who might be watching may not understand what a TNC and all these other things are.
Will do. Thank you. An FNC is a final non-confirmation, which is the final notice that you are not confirmed. It is not redressable. In other words, there's no appeal mechanism for that, which may get to the issue you both were talking about with Americans who are work authorized may get a bad shake out of the system. So improving government data sets, increasing employee awareness, and making sure employees have a sufficient amount of time to redress the TNC notices is really what's needed here. Now I'd like to turn briefly to the issue of identity theft that both of you have mentioned. This is a very important issue, and it is one that the system has not been able to address. And that's when I would use, if I were not work authorized, would use one of your data sets to say that my Social Security number is this and my driver's license is this, and it goes through the system. It says I'm work authorized when I'm really not. Westat did a study a couple of years ago. They found that about 3% of the confirmed work authorized people really aren't. In other words, it creates a false positive. And sometimes this is done by individual workers getting an identity that works. Sometimes it's done with the complicity of the employer. The employer says these work, let's enter these and we'll put you on our payroll. The USCIS has taken a number of steps to try to address this, like a photo matching tool for 3 of the 26 documents that you can use to validate your ability to work in the United States. But again, this whole system hinges on the integrity of the employer. The employer looks at the photo on the screen, looks at the photo that you present, or looks at you, who is before them, and either says it is or is not a match. So that is an issue that they have to work on a little bit more, finding a key to unlocking the identity theft issue. Turning to some of the discrimination issues, there is concern that people who have hyphenated names may get a bad shake out of the system, or people who have hyphenated names may encounter certain challenges that those of us who don't do not. They may order their names in a certain sequence differently on different documents. There's nothing against the law to do that, and it's going to trigger a tentative non-confirmation. USCIS has a monitoring and compliance unit that they have to try to identify discriminatory behaviors among employees, such as seeing if a person is not given work assignments or reduced pay until the final confirmation comes through. This is against the law, but again, with about 80 people across the country and no on-site inspection, I take that back, there was one at the Social Security Administration, it's difficult to determine whether that's going to work or not. My last point from our report is resources. Like the I-9 system, unless the E-Verify system is properly resourced, it is not likely to work well. This is because you have to have someone on site to make sure that the system is properly used, and to the extent possible, to make sure that identity theft is minimized or eliminated. USCIS has to rely on ICE for investigating, sanctioning, and seeking prosecution of non-compliant employers, but given its priorities, ICE is not likely to do a whole lot in this area. So policy decisions are going to have to be made on how many resources the Congress wants to put into this system. My last thing is some impacts on SSA. First, to the extent that they need to resolve these TNCs, tentative non-confirmations, it does take time away from other duties. When the TNC rate goes down from 8 to 1.7%, that's helpful. If we go to a mandatory system, we may need more resources so it does not cut into the SSA workload. And another thing that could cut into the SSA workload is the self-check system, where an employee or a potential employee like you and me could query a system to see if the system would identify us as work authorized. It is new, it's being piloted. While the pilot is ongoing, it doesn't seem to be stressing the SSA workload too much. If it goes mandatory or if the pilot is expanded nationwide, it could have an effect. But I'll let the Social Security Administration discuss that. And that concludes my statement. I'd be happy to answer any question.
Thank you, sir. Ms. LaConfora. La or La?
LaConfora.
LaConfora. Thank you. You're recognized.
Thank you.
For 5 minutes.
Chairman Johnson, Ranking Member Becerra, and members of the subcommittee, thank you for the opportunity to discuss SSA's supporting role in E-Verify, DHS's electronic employment eligibility verification system. I'd like to start by briefly describing the purpose of our Social Security numbers, or SSNs. Assigning SSNs is key to administering Social Security programs. We established the SSN as a way for employers to report an employee's earnings accurately. We use the SSN to credit wages to the earnings record that we maintain for each worker. The earnings record is the basis for determining eligibility for and the amount of Social Security benefits. The SSN also plays a key role in E-Verify. By law, all employers are required to verify the identity and employment eligibility of new employees. E-Verify is a voluntary electronic tool that employers can use to comply with the law. When an employer submits information about a new hire, DHS sends this information to us electronically to verify the SSN, the name, and the date of birth in our records. For new hires alleging U.S. citizenship, we also confirm citizenship based on the information that we have in our records. For any naturalized citizen whose U.S. citizenship we cannot confirm using our records, DHS verifies naturalization and thus the authorization to work. For non-citizens, if there is a match with our records, DHS will then determine the current work authorization status. DHS notifies the employer of the results of these verifications. So far this fiscal year, we've handled about 7.5 million queries. In fiscal year 2010, E-Verify handled over 16.5 million queries and automatically confirmed work authorization in about 98% of these queries instantly or within 24 hours. The remaining 2% received an initial systems mismatch. We call that a tentative non-confirmation. Of that 2%, just under half contacted us at Social Security to resolve the mismatch. When an individual comes into one of our offices with a tentative non-confirmation, we work to resolve the discrepancy. For example, the person may need to change their name in our records due to a marriage or a divorce that they had not previously reported to us. It is important to note that we need to verify the identity of any individual whose record we update. That is why we must process almost all of these updates during face-to-face interviews in our local offices. In some cases, we may be unable to resolve the discrepancy the same day because the individual may need to obtain evidence, such as a marriage certificate. We use EV-Star, which is a web-based portal, to update the E-Verify system with the status of a pending case. Once we resolve the discrepancy by updating our records, or by determining that our records should not be changed, we again update EV-Star to show the outcome of the case. The employer can check E-Verify for the status of the case and see the final confirmation or non-confirmation. We've worked with DHS over the last few years to improve the E-Verify system. For example, in 2009, we completed a significant improvement to our computer systems that support E-Verify. This improved system ensures that there is no interference between our mission-critical workloads and DHS's E-Verify program. At the request of DHS, we designed the system to handle up to 60 million queries per year. With additional hardware and funding, we could increase our capacity if the need arises. Even with this and other improvements, we remain focused on further reducing the need for workers to visit our local offices. Each year, DHS provides funds to cover our E-Verify related costs. Our costs include systems maintenance costs and the cost of assisting individuals to resolve the tentative non-confirmations. Receiving timely and adequate reimbursement from DHS for E-Verify is critical. In conclusion, I thank you for giving me this opportunity to discuss our role in assisting DHS to administer the E-Verify system. I'd be happy to answer any questions you may have.
Thank you, ma'am. Ms. Moran, welcome. You're recognized for 5 minutes.
Thank you. Good afternoon, Chairman Johnson, Ranking Member Becerra, and members of the committee. The opportunity to testify on E-Verify. The National Immigration Law Center has worked on E-Verify since it was implemented in 1997, and I've personally advocated for improvements on this program for almost a decade. E-Verify faces a number of challenges despite the progress that it's made, and these challenges would be greatly exacerbated if this program is made mandatory. That's why it's particularly troubling that there may be a bill in the House this year to make this program mandatory, because it almost certainly would pass. According to the Congressional Budget Office, there would be over $17 billion in tax losses because undocumented workers would not leave the country. They and their employers who are currently paying taxes would simply go underground to get around the system. Number two, SSA has testified in 2007 that over 3 million workers would have to go to SSA to stand in line and correct database errors or lose their jobs. And this is a system, as Mr. Stana has testified, doesn't detect half of undocumented workers. Additionally, if a mandatory system is put online without legalizing the 8 million undocumented workers in our economy, it's going to set the system up for failure, not to mention to decimate industries like agriculture. So I want to address the error rates. The 98% error rate is very impressive. There have been a lot of improvements, but I'd like to talk about the numbers. Using Weststat's conservative estimates, in the mandatory system, you would have 1.2 million people standing in line in SSA to correct their records or lose their jobs. And you'd have 770,000 people likely losing their jobs. This is an underestimate because every employer that's audited their own data comes up with higher error rates. To make this really concrete, with a 2% error rate, in Texas, that would be 244,000 people going to SSA or losing their jobs. And in California, that'd be 362,000 people, 78,000 alone in LA going to those 7 SSA offices.
Busy in Texas.
So these are future projections, but using Westat statistics in FY10 alone, 80,000 U.S. citizens and lawful immigrants lost their jobs. Jessica, a native-born U.S. citizen from Southern Florida, is one of those people who called our office. She got a job offer that she accepted at a good-paying telecommunications company. They told her she got a TNC. She went to SSA. She provided the documentation. They said, "You're all set. Here's some paper." She went back to her employer, who at first said, "Okay." 3 days later, they said, "I'm sorry, you got a final non-confirmation. We're going to have to fire you." She went back to SSA, waited in line, and said, "I thought it was okay." They said, "It is okay." She went back to the employer, and the employer said, "I'm sorry." She was very dogged. She called USCIS, DHS, finally called us. She was out of work for 3 months, including over the Christmas holiday, and she now has a lower-paying job. The worst part about this is there is no due process in the system. There is nothing we can do for Jessica to get back her wages or to get back her job. So it's important to note that Jessica's not the only one that faces these challenges at SSA. People have to take off time from work. It takes some time. They have to go back multiple times. I want to highlight Arizona because I think it's a good window into what a mandatory system could look like. Arizona is the first state to make E-Verify mandatory. And there's 3 main takeaways. 1, undocumented workers didn't leave the state, they didn't leave the country, they went into the underground economy, or they're now popping up as independent contractors. Number 2, employers are coaching workers how to get around the system. And number 3, despite penalties and mandates, half of employers aren't even using it. So you might think this is all worth it if the system worked, but again, 54% of undocumented workers aren't detected by this system. So what are the solutions? As I said in my opening statement, E-Verify has made a number of improvements, but it's just not ready for prime time. If and when Congress decides to make this program mandatory, there's a number of policies that have to accompany it, and they're in my written testimony, but I want to highlight 3. Number 1, it has to be paired with a path to legal status for the 8 million undocumented workers. People aren't going to pack their bags because of E-Verify. They're going to stay here, and there's going to be major repercussions for the economy. Number 2, we have to create due process. So people have a way to challenge these errors, that they get back pay if they lose their jobs. It's 9% unemployment. We can't have 1 million workers losing their jobs. And number 3, you should phase in E-Verify with performance evaluations along the way for database accuracy, privacy, employer compliance, to make sure the system works for workers and businesses alike. So in a year when Congress, it's all about cutting budgets, high-performance programs, E-Verify just doesn't make sense. When this bill goes to the House floor, you're going to hear a lot about protecting jobs and undocumented immigrants, but I think the members of this committee can play a really key role to highlight the impact of SSA and the impact on U.S. citizens, who are the people that are most affected by this program. So thank you.
Thank you, ma'am. It sounds like you don't like the program. You know, we got to do something to stop the illegal workers.
We pair it with legalization, we can talk.
Do what?
We pair it with legalization, then we can talk.
Dr. Antone, you're recognized for 5 minutes. Thank you for being here.
Good afternoon, Chairman Johnson, Ranking Member Becerra, and members of the subcommittee. Thank you for the opportunity to testify. The statement represents my own professional position as well as that of the Association for Computing Machinery's U.S. Public Policy Council. By way of introduction, I'm a professor of software engineering at North Carolina State University and the director of an academic privacy research center. In addition, I serve on several industry and government technical boards of advisors, including the DHS Data Privacy and Integrity Advisory Committee. The E-Verify pilot system is intended to ensure that only authorized citizens and legal residents can be employed in the United States. A laudable objective, especially in a time of notable unemployment. Unfortunately, the intent has not matched the realization. Complex systems such as E-Verify are fallible and often misused and subject to mission creep. One large-scale evaluation of E-Verify reported that the majority of illegal immigrants checked through the system were incorrectly deemed eligible to work, primarily as a result of identity fraud. Thus, E-Verify remains vulnerable to and incentivizes the use of identity fraud. Among the issues noted in my written testimony are three that are especially critical to consider from a systems engineering perspective. First, E-Verify must be able to accurately identify the individuals and employers authorized to use the system in a trustworthy manner before it is widely deployed. Second, proof of success with a pilot must be required before extensively expanding it. Third, complex systems such as E-Verify are often misused and repurposed in ways that violate sound principles of security and good software engineering. This should be considered in the design of the system and in supporting legislation. Given the identification and authentication concerns in E-Verify, it's important to distinguish between an identifier and an authenticator. Both have very special technical meanings and are often confused. In my written testimony, I describe the differences between identification and authentication. In brief, an identifier is a label associated with a person, and an authenticator provides a basis to believe that some identifier accurately labels the person. Within the context of E-Verify, the self-check pilot system, which we heard of a few minutes ago, it authenticates individuals by requesting information that can easily be obtained via the white pages and public tax records by individuals other than the holder of the Social Security number. The requested information is not sufficient for proper authentication. The pilot allows unauthorized individuals and fraudsters to access the system, allowing them to check stolen information to determine if it can be used to craft a new fraudulent identity to obtain employment. As currently configured, mandated use of E-Verify would encourage an increase in computer fraud, abuse, and identity theft. Additionally, to protect the innocent, employers who take action on non-confirmation returns without informing applicants and providing them an opportunity to appeal and correct mistaken records must face strong penalties. Exceptions for cases of natural disaster or emergency should also be built in. Under such circumstances, requirements should be waived or suspended when seeking new employment. In the time remaining, I will highlight a few recommendations from my written testimony, again from a systems engineering perspective. First, it is critical to eliminate the weaknesses in E-Verify and objectively audit the pilot before it is scaled up or extended to verify individuals for anything other than employment. Lack of proper system validation and verification will almost certainly lead to cost and schedule overruns, system breakdowns, intrusions, and perhaps obsolescence. Second, it is imperative that vulnerabilities be examined and risks addressed to protect the system as well as the identity of the individuals whose information is contained within it. Third, adopting biometric technologies as a solution to the E-Verify authentication problem would be premature and is unlikely to solve some of the fundamental problems with the current system. In conclusion, we are encouraged by your attention to these issues, and the competing professionals that I represent stand ready to help you in your efforts. And thank you for your attention.
Thank you, ma'am. I appreciate your comments. Mr. Fregelman, welcome. You're recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Becerra, members of the subcommittee. I wish to thank you for your kind invitation to share my thoughts on employment eligibility verification and the problems U.S. employers face. Before we discuss E-Verify, I'd like to acknowledge the fine job done by the U.S. Citizenship and Immigration Services in expanding and improving the program. Based on the agency's last numbers, enrollment is up to 254,000 employers, and you've heard that 98.3% of the queries result in automatic response within 24 hours, which shows a steady improvement over the past decade. However, the number of participants only represents about 3% of all employers, and scalability is still a concern. While E-Verify has become very effective in matching a name with a Social Security number, it is not effective in making certain that the employee is who he or she claims to be on the Form I-9. According to a December 2009 report, 54% of unauthorized workers who undergo E-Verify are erroneously confirmed as work authorized. E-Verify has made some progress towards solving this problem. One example is the incorporation of photographic images from green cards, Department of Homeland Security work authorization cards, and U.S. passports. And we appreciate that there are plans to include driver's license data from motor vehicles departments around the country, but so far there's only one state involved in a pilot program. Over the past 2 years, the employer community has witnessed much more scrutiny by the Immigration and Customs Enforcement Agency. Not that I'm objecting to enforcement of the law, I think that's perfectly appropriate, but employers want certainty. Employers want to know they have a true safe harbor when they obey the law, and those are really the two cornerstones. Under the status quo, employers do not have clear guidance on what to do when informed of a Social Security record mismatch or when the information does not match government records. There's no assurance that the employers are not victims of identity fraud. I believe the solution to the unauthorized employment problem, and ultimately an important weapon in addressing illegal migration, is reliable employment eligibility verification. Before we can eliminate false non-confirmations in E-Verify, there must be sufficient resources allocated to the Social Security Administration to clean up its records. We also need clear guidance on what to do with Social Security number mismatches. However, we do not believe it's necessary for all employers to re-verify their entire workforce. For the system to be effective, additional steps are necessary to stop identity fraud. Matching photographs, of course, will have a positive impact, but it does not eliminate subjectivity on the part of the employer. Instead, this will require incorporating biometric technology, such as that proposed in the Johnson-Giffords new Employee Verification Act and other comparable technology. If we can stop identity fraud, it will give law-abiding employers a safe harbor and at the same time take away the subjectivity that encourages discrimination, either deliberate or inadvertent. Further, having an effective and reliable system would strengthen the argument for federal preemption in immigration enforcement, something that business and immigrant rights advocates both want. Finally, an effective eligibility program is a critical component of law enforcement, filling the gaps that border control and visa tracking currently leave in the process. Thank you for this opportunity to share my thoughts.
Thank you, sir. What state is the state that's using driver's license?
Mississippi.
Thank you. We've got a vote. There'll be 2 votes. I'm going to put the committee in recess for 30 minutes or until we get back if it's sooner. Thank you. We stand in recess. Well, 30 minutes. So we can get started. Committee, come back to order. I'd like to ask Mr. Fragaman, the most critical issue facing America today is jobs. And I think without jobs and job creation, our country's doomed to a lower standard of living for decades to come. What steps need to be taken, in your opinion, to ensure that employment verification, in particular an expanded E-Verify, doesn't complicate or impede creating a job and hiring the right person for the job? Turn on your mic. Turn on your mic.
That's a very critical issue. I think the most important factor is to move into this slowly if we have mandatory verification, and to make sure that that it's possible to scale the system to the level that it would need to be, and to, as they say, get it right. Now, in order to get it right,
Say scale the system, what do you mean?
I mean, in terms of increasing it, the system now covers about 3% of employers.
We've been fighting that for years.
And it needs to cover 100%, which means we have to add about 7.5 million employers to the system, which means that the volume of transactions that E-Verify, for instance, would have to be able to accommodate would be, would be multiples of what it is currently. And the problems that software encounters when you try to increase its capacity by that magnitude. And the second thing is that probably
no, but Social Security claims they've got the most modern system available today.
Yeah. Well, I
mean, that's what they tell me.
Yeah, well, they might, except that the number of tentative non-confirmations, when you multiply it by that number of employees, becomes a very significant number. If you figure about 1.5% of the cases wind up in tentative, it's 1.7%, but the ones that don't get resolved easily. But the other aspect of it is that there be adequate resources dedicated to Social Security, so that they do it right, that the system be fully electronic, that it incorporate biometrics or other fraud prevention techniques or software, and secondly, that we have a uniform law, that this applies everywhere and it preempts the current state laws. I think that's very important, and that the employer is offered a safe harbor. Because at the end of the day, it's really the government's responsibility to get the system right, to protect the employer and to offer a safe harbor and to protect the employees against potential discrimination. But to accomplish all those goals, it really has to be a government-driven system that can prevent identity fraud.
Well, every expert we've talked to acknowledged the fact that E-Verify can't detect identity fraud very well, and may in fact encourage it. So that puts the employer on the front line of trying to detect and prevent identity fraud. So can you tell us the challenges faced by your companies in their attempts to detect identity illegalities and yet fill the jobs that America needs?
I think it's very frustrating to companies who have to go through this process, because essentially they have to accept the documentation that is given to them by the employee, as long as it looks reasonable on its face. And there's really nothing further, no further steps they can take. If they ask for additional documentation, they could easily be accused of discrimination. And the companies, of course, are generally very concerned about making certain they do things right, and they don't hire workers that aren't legally authorized to work, because of course they could lose these employees in an enforcement action, and then of course that would hinder their ability to deliver the service that they're delivering. So it's a counterintuitive situation, because you're presented with documentation. You really don't like the way the documentation looks, but you have no reason to say with certainty that there's anything inappropriate, and you just have to accept it. So I think it puts the companies in a extremely difficult position. And of course, if it turns out that the documentation, in fact, is fraudulent, then the employer's whole business is at risk in an enforcement action if he loses a big portion of his workforce.
Thank you very much. My time's expired. Mr. Becerra, you're recognized for 5.
Mr. Chairman, thank you very much, and I thank each and every one of you for your testimony. I don't believe there's a person in this Congress, and I suspect sitting here in this audience, who wouldn't agree that as a sovereign nation, we have to do everything we can to make sure that we understand who's in our country and who's securing employment in our country. And I know that we continue to try to figure out the best way to get there. And so your testimony is important, because Congress is going to make every effort to try to take us to a place where we can tell the world, not just Americans, tell the world that we're going to determine the best way to figure out who should come into the country and who should be able to work in our country. And so I wish you a great deal of good fortune as you continue to assemble the information and the data that will help us make the best decisions here. I'm concerned about 2 things in particular. As we try to move forward in verification for employment, that we're not undermining the essential work that's supposed to be done by the agencies that might be placed in a position of charge to do the work. So in the case of the Social Security Administration, you're already backlogged in trying to deal with disability claims from Americans who are trying to get their benefits. You're backlogged when it comes to trying to secure the different resources you need to do the other things that come from having the most popular identifier in the world, the Social Security number. And so I am wondering if you can give us a better sense. Right now, E-Verify is a program used in, what, 2 or 3% of the employment community? And if you expand it and make it mandatory throughout the nation, we're expanding it dramatically. And if we've already heard the stories of the potential fraud, potential misuse of identity, and certainly the dramatic dislodgement of employment that an American may have secured rightfully and then loses it, how are we prepared then to move to a fully national mandatory system? And so perhaps what I can do is ask Mr. Stana first to give us a sense if you think any of the federal agencies that would be in charge of a nationwide mandatory system are equipped today with resources and personnel to ramp up to full 100% participation of the employment community.
Well, I think as you pointed out in your statement, the CBO estimated it would take billions of dollars to make sure that Social Security and DHS and whoever else would be involved would have both the technology and the personnel to make this happen. Currently, do they have that to ramp up right away to a mandatory system? Probably not, but with proper resources, they could get there. The other questions you raised about the ID theft and making sure that you don't have false negatives, those we have to get on top of. This whole system is not about 95% of the population. It's about the 5%.
Yeah. But the 95% of the population might pay the price as we try to deal with that 5%.
Well, you can't ignore the 95%.
Ms. Lankenfor, let me ask you this. Social Security in this tough budget environment is taking a hit in this 2011 budget. Chances are it might take a hit in the 2012 budget. You're already having a difficult time dealing with all these other responsibilities you have to our Americans who are applying for retirement benefits, for disability benefits, survivors benefits. Can Social Security ramp up to 100% E-Verify participation without sufficient resources to do this?
The simple answer is no, Mr. Becerra. We appreciate and share your concerns about funding. It really depends largely on what you consider mandatory 100% expansion. Right now, E-Verify is largely used for new hires, with few exceptions. And if you look at the current volumes, about 16.5 million queries a year. If you ramp it up to new hires nationwide, that would be around 60 million queries a year. If you ramp it up even further to include current employees, you could be getting up to 140 million queries a year or more. So it depends on what we consider the mandate, but certainly any mandate would have a significant impact on Social Security, increase traffic in our local offices, and we would need to be funded for that. And I would also support the comment earlier made by one of my colleagues to say that any mandatory move should be phased in so that we have the opportunity to ramp up and hire as needed.
And Dr. Anton, and I hope Mr. Fragerman, you as well, will continue to provide us with some information that helps us pinpoint some of what your testimony really focused on, and that is how you make this work. How do you collect the information? How do you deal with this internet fraud that's out there? We really need that to be able to move forward. And Ms. Brand, I hope you'll continue to give us the real live examples of individuals, U.S. citizens, lawful permanent residents who've been impacted because we haven't done this perhaps as quickly in implementing a workable program as we'd like. And so as we continue to figure out how to ramp up, I hope you all will continue to give us information. Unfortunately, my time has expired, but I would love to have gotten into it more with you all, but I appreciate very much your time with us today. Thank you, Mr. Chairman.
Thank you. I appreciate your comments. Mr. Paulson, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Fragerman, small businesses are our top job providers, and how much of a barrier is not having internet access for using E-Verify for those folks?
Well, not having internet access certainly makes it much more difficult. As you know, you can do verification over the telephone, but that's not a particularly desirable way to do it. I suppose the good news is this is becoming less of a problem as telephones now are morphing into internet-enabled devices. So I think it'll become less of a problem over a period of time, but certainly it's an issue now. And the other big issue too, I think, for small businesses is just the impact on the small businesses if they have staff, since they tend to not have too many employees that have to go, quote, hang around the Social Security office with thousands of other people who'll be doing the same thing at the same time. You can imagine what the impact of that would be on these smaller companies.
And I was kind of wondering if you thought that smaller employers essentially should be held to the same standard as larger companies in terms of a compliance measure if they can't get access to the internet like larger employers. And are you concerned that a work verification system might not only discriminate against the workers but also against potential small employers? And I should ask you, what about the situation where a potential worker is caught in a tentative non-confirmation problem and the need for communications between Social Security and the employer become critical?
Yeah, I mean, once again, that's a big issue. I mean, I think in fact most situations are going to require the employee to actually go to the Social Security office or whatever to try to get these problems resolved. I don't know how many of them are really going to be successfully resolved electronically, but certainly not having internet access would be a big problem, and I think it would require on behalf of the smaller employers that they may just have to try to, as I say, try to use some of these technologies so that they can get more in the game. Now, as far as is whether it would be reasonable to exempt them, I think that becomes difficult when you consider the number of small employers there are, and the fact that frequently these smaller employers are situations where undocumented aliens may be employed. So I think giving them some sort of an exemption would probably be a good idea, maybe for a period of time,
That was my
but
follow-up. I was just
yeah.
curious if you thought it would be a reasonable option to give them an exemption for certification for a business, if the smaller ones in particular, if they've shown to be good employers or they've had a good faith effort to actually abide by the law.
Yeah, I think it would be very reasonable to do that for, as I say, a period of time, because as we discussed a minute ago, it would be important to phase in the program, and they could be, larger employers could be phased in first before smaller employers.
Okay, thank you. I yield back, Mr. Chairman.
Thank you, sir. Mr. Berg, you're recognized for 5.
Thank you, Mr. Chairman. My question, Ms. Lacaforna, some new hires that are authorized to work, we heard a little bit about this, are receiving erroneous tentative nonconformance from the E-Verify system. You know, it seems like we've got too much bureaucracy in here that's really creating a problem for people that are obviously getting kicked or flagged with a system. And so I guess my question is, you know, we know that Social Security can extend the deadline, and they have field office employees who can make the entry into the electronic system, the EV Star. I guess just is there, what is SSA doing to try and improve this, or, again, keeping people from falling through the cracks?
Thank you for the question. Over the past few years, we've worked closely with DHS to decrease the number of tentative non-confirmations. It used to be somewhere, I think, as my colleague said, up around 8%. Right now, the total tentative non-confirmations are around 1.7% of the total, and less than 1% actually come to Social Security. So the other tentative non-confirmations may be resolved through DHS. So we get less than 1 visit for every 100 queries coming through the system. So that's far lower than it has been in previous years. And in terms of the EV Star system, we have, as a matter of fact, next week, an enhancement to the system coming in where if someone walks into one of our offices as a result of a tentative non-confirmation, they don't have to tell our employee that. They can say, listen, I have some sort of discrepancy I need to resolve. And what will happen is when our employee goes into the system, an alert will pop up saying, check EV Star, so that we can assure that we catch every one of these cases and then document it properly in the system. So we expect that that enhancement will significantly increase our use of EV Star.
Okay, thank you. I'll yield back, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Fragman, would you talk about the impact of the patchwork of laws on employers, if you could emphasize that, and then about the challenges this creates for Homeland Security in determining the volume of E-Verify workloads?
Well, the impact is very significant. I mean, the state laws basically differ from each other. They frequently differ from the federal law. They have different paperwork requirements. They struggle with issues that would seem to be very simple, but with modern employment have become more less obvious, which is, for instance, what is the place of employment? If you physically work in one location, but you report into and you're paid by an employer or an office that's in the state, or perhaps there's no office at all in the state, but you actually, in fact, render services that benefit, for instance, a company with whom you have a contract in that state. So they have a lot of difficulty identifying what the different standards are. And then, of course, you have your virtual employees who are just working at home. And so the bottom line is that it's a very, very expensive proposition for corporations that try to track all these different rules and try to comply with them on a state-by-state basis.
Okay, thank you. And Ms. Canfra, sorry, last name like Smith, I'm easily challenged. Can you, now that everything is fully reimbursed to Social Security, right?
Yes, DHS reimburses us for all of our costs.
And is there any, can you elaborate on how that reimbursement takes place?
Sure. What happens is at the beginning of the year, DHS will estimate the number of queries that they expect. We at Social Security estimate the amount of the fallout that we expect to happen. In other words, the number of people that will actually walk into a field office. And with those two numbers, we then estimate the amount of money that DHS should reimburse us for the year, and they pay us that money up front. And then at the end of the year, after we know how many queries we actually got and how many field office visits we actually got, then we reconcile those numbers and we, sort out the change.
Thank you. Thank you, Mr. Chairman. I yield back.
Thank you. Mr. T. Berry, do you wish to question?
Thank you, Mr. Chairman. As I left, I told Mr. Fregeman, and I'll guess to let everybody else know before I ask the question, just this morning I had an employer talk to me about this issue. Family-owned business participates voluntarily in the E-Verify system, has been very frustrated with the lack of continuous continuity in the system. Sometimes it takes up to 7 days for verification. At that point, usually if it takes that long, the applicant that he's going to hire is gone, goes to another employer who doesn't have an E-Verify system. So he's frustrated from that perspective. He's frustrated that this small business owner who owns 12 restaurants in Ohio was audited in a voluntary manner by ICE and found that 83 of his employees in total that were E-Verified had given him incorrect information on his I-9, on the I-9. So he got fined. He lost the 83 employees, fired the 83 employees, and they're probably working somewhere else. And here is an employer who's actually trying to participate in the system. So I have grave concerns about how a mandatory system would work when clearly the voluntary system is not working for employers, some employers today. So I'd like to ask each of you, and we can start at the end here, what do I tell my constituents why I should support a mandatory system when clearly the voluntary system is not working?
You know, when we did our work that resulted in the report that was just issued a few months ago, we went out to the state of Arizona and North Carolina, a few other places, and talked to employer groups and asked them what they wanted in a system. And some of the issues you're bringing up today really weren't on their radar screen. They said they want something that's reliable, fast, and not burdensome. And they're worried about the other guy having a competitive advantage like you were talking about. You lose an employee and he goes down the street and gets hired. So I think what I would say to the person is to the extent that we judge that this system has those dimensions, reliable, fast, unburdensome, that then it would be ready for prime time in our estimation.
But today he would argue, I'm not sure.
Yeah, listening to that case, so
it's not reliable. The system, the E-Verify system, is not reliable. It sometimes takes up to 7 days. And in this case, not very timely or accurate.
Yeah, without knowing the facts and circumstances of that case, maybe he described it differently. He shouldn't have sent the information into the E-Verify until he actually hired the individual. You shouldn't use it for screening. That's a no-no. But if it was 7 days, that is an exception. But if that happens a lot, then that's of concern.
It happens a lot, he said.
I would say SSA has a very limited role in E-Verify. We obviously have a database, as was mentioned earlier, with over 450 million records, social security numbers, dates of birth, and some citizenship information. But DHS is responsible for all other aspects of the E-Verify system, so I'd have to defer to them on largely to your
That's
question.
Fair. Ms. Moran?
I'm not going to convince you to support a mandatory system. In fact, I don't think that you should. What we need to do is employers that are in your state, we need to find a solution to the broken immigration system. He or she wants those 83 employees. They need employment. We need to just find a solution so that employer isn't liable for immigration violations and he or she can get the workers that they need.
Thanks.
I'd just like to point out that there's another issue that has been raised that affects small employers, which is the fact that small employers generally don't have the resources to properly secure their systems. And so in addition to being fined for that kind of thing, they're going to have data breaches. They're going to have databases which contain information that identifies other people, and they're going to be easy targets for people to hack into their systems inside or out. And so That's another consideration, is they don't have the resources, not just internet access, but the fact that their systems are vulnerable to botnets they don't even know that are on there, and viruses, et cetera.
Great point. Thank you. Sir?
Well, it seems to me that if the government mandates that you go through this process, that they then have to assure that as a trade-off, that the system will be certain and that you'll be given a safe haven if you do what you're supposed to do. So before the system, in my mind, is ready for prime time, it has to be improved to the point where that's possible, and it has to address this whole issue of identity fraud. And until it addresses identity fraud, has adequate resources, fully electronic, et cetera, it should not be mandated because it's not reliable.
Thank you. You back.
Thank you, Mr. Brady. You're recognized.
Chairman, thank you for holding this hearing. Really appreciate the comments of all the witnesses today. I'm convinced that the broader issue that we have to close the back door of illegal immigration so that we can keep open the front door of legal immigration. Workforce verification, timely and accurate, is the key to that, to do it successfully and fairly. Dr. Antone, you had an interesting comment in your testimony about mission creep and how databases start to tie into one another, and before you know it, you're going to have a dangerous situation. Some have suggested that Social Security, IRS, and Homeland Security share taxpayer data and force workforce hires. We hear that often. We at the committee have been very apprehensive about any sharing of taxpayer data and have jurisdiction regarding Section 6103 in the IRS code that prevents it. In fact, our staff asked the Joint Committee on Taxation to prepare a report on these provisions in preparation for this hearing, and Mr. Chairman, I request that this report be entered into the hearing record.
Without objection.
So, Doctor, can you speak to the taxpayer data issue and mission creep and workforce enforcement?
Certainly. So from a privacy point of view, clearly when you start commingling IRS data with other databases about citizens in the United States, that raises a lot of red flags. As a technologist, I can say that requiring, for instance, authentication. For authentication, let's say that you had to provide, what was the figure on line 19 in your IRS statement or tax returns from last year? Well, that's something that no one else can get. That's something that only I can look up. And so from that perspective, as an authenticator, it's pretty strong. But the concern then is that that raises a lot of risks once you start providing that kind of access between systems. And every time you start piggybacking databases, and you are ultimately increasing the risk of security problems, transmission of information, data leaks, peeping, data peeping, by like when there's celebrity peeping, et cetera. And so it raises a lot of the different risks that have to be considered. And how do you secure all of those transactions as well?
In layman's terms, businesses and agencies today focus on keeping their data secure. How much greater does the risk increase when you start sharing those types of data across agencies?
Well, ultimately, the more data that you have about someone in a database, the easier it is to access a lot more information and cobble together new identities. And so it becomes a very rich target for attack. And so that's something the government has to think about is, what do we really, there is no such thing as a secure system. We have centuries of experience with war to show that there is no such thing as a secure system or country, et cetera. And so with that knowledge, we have to think about, do we really want a system that will eventually be broken into, that will make it easier for people to propagate identity fraud? So there's just different risks that we have to do. And we need to consider, how do you design this system in such a way that we address the real problem at hand, instead of patching things on in the hopes that we keep putting Band-Aids on. Okay, well, maybe if we just check people to see whether or not they're eligible to work. And then we have all of these other problems. And the real problem, I think, is an immigration problem. So I'll just throw that
Got it.
out there.
Thank you, Doctor. Chairman, thank you.
Thank you, Mr. Brady. That's interesting. You know your line 19 on your IRS form.
I don't, I just threw that out there. But the point is that I would have to look it up, and if I have to look it up, then someone else can't use it.
Yeah, I'm not sure I could find mine 10 days after I file a form. You know, all of you, use of biometric data is always another proposal for ID and authentication, and we've been talking about that for a long time, and of course, it's not perfect either, but can each of you comment on biometrics and what you think of them?
Yeah, let me just answer that two ways. First off, it could be very expensive to do it right. And to do it right might be something other than putting a chip in a card and sliding it into a reader, and because those kinds of systems have been hacked in a matter of hours. So that's not good. You have to have a separate data set. So that could be very expensive, but maybe in some form necessary to make this thing work. Second thing is it raises all kinds of privacy concerns. How much of your identity should the government have? And that's not a question that I'm ready to answer. But should the government have my retina scan? Should the government have my fingerprint? Well, they already have my fingerprints. But how much information do you want? And then you get into the data privacy and security issues that.
Yeah, I'd like to give it to them so I can get through the airport quicker.
Well, I mean, that's the other thing. I mean, you know, some people would be perfectly willing to give it up if they could bypass this system somehow. They just put their hand on a reader and boom, you're work authorized. Others are very sensitive to that.
Thank you.
Okay, I'll preface my comment by saying I'm not an expert in biometrics, but I do agree that incorporating biometrics into E-Verify would be a costly proposition. And so, as you know, DHS, it was mentioned earlier, is allowing employers now to access passport photos and is working to obtain driver's license photos. And looking at photos is one means of identity assurance, although not foolproof. So I think decision makers need to weigh those options against the biometric option to see what is cost effective and what gets the job done to the extent possible.
Thank you.
So the cost and the accuracy issues have already been mentioned, and I encourage you to look. There's been some studies of the Transportation Worker Identification Credential, the TWIC card. It's like $1 billion, huge error rates. It's just kind of been a mess. So I'd encourage you to look at that. I think is the closest thing. But the point is that E-Verify what?
It worked.
Yeah, I mean, for some it does, but there's also been some pretty high error rates, and also the census folks got a 20% error rate on fingerprints when they tried to do it for the workers last time around. So I think the point is that E-Verify, biometrics, nothing's a magic bullet. Again, not to repeat myself, but if you still have undocumented workers in the economy, just like E-Verify, they're just going to go underground and get around this system. So.
Thank you.
So I would just note that if you also add biometrics to a database, that becomes a very, very rich, wonderful asset for anyone who wants to gain access to it. And another challenge with biometrics is this is another single-factor authentication approach. And so we really are advocating a layered approach where you have multiple ways of authenticating people. And there are places in which biometrics, I think, work really well. For instance, to enter in the Olympic Village, there's always a hand geometry, and your hand geometry gets compared to your badge. That isn't retained in any database, so I have to have my credential with me to get in. And so that's a very nice approach to do it because you don't have the responsibility of having a database with all those biometrics stored in it. On the other hand, that's extremely expensive because that means you have to have a reader at every single place of employment. And there can be hardware failures associated with that.
Thank you.
If over half of the unauthorized workers who undergo E-Verify are erroneously confirmed as work authorized, it seems as though we're creating a pretty vast system which impacts on the whole populace, and we're not being very effective at ferreting out unauthorized workers. So it seems to me that that is problematic as it might be because it costs a fair amount of money. You have to be able to still stop the use of breeder documents, which can lead to receiving identification that would suggest that in fact you're someone different than you are, and the obvious data security problems. Notwithstanding all those problems, it seems to me that unless we tackle those, at the end of the day, I don't know that we're being very effective in terms of keeping unauthorized workers out of the workforce.
Yeah, it's a cumbersome idea, but it might work. Mr. Becerra, do you care to question?
If you actually inspired a question that sort of stems from something Dr. Anton mentioned earlier. You mentioned that trying to expand E-Verify when it's prone to errors, prone to intrusion, loss of privacy, that you, at the very end, you close by saying it's almost as if we're trying to build a system that hasn't been proven to work effectively because we have a decrepit immigration system that's not helping us keep tabs of folks in the first place who are authorized to work. So it sounds like we're piling on top of a broken system other systems that we're not quite sure yet are ready for prime time, may cause difficulties for Americans' privacy and security, and may lead to a lot of businessmen and women having to go through some expense and perhaps difficulties with their business if they must go through a system that doesn't always give them the check they need. And so it seems like rather than pile on, we should clear the dust and deal with the foundation of why we're talking about coming up with a verification system in the first place.
Yes. I wholeheartedly agree, and as you were speaking, it reminded me of everything we would read about business process reengineering during the late 80s, early 90s, where one of the problems is that people were building systems that automated existing broken business processes and practices. And so that's why systems become obsolete. And so I think it's really good to think out of the box and think really, really big. This is a grand challenge, if you will. And how do we solve the problem and then build a system that really supports a well-designed business practice and business process?
And Mr. Fragerman, question for you. If you could take control of this, could you devise a system that would work for verification purposes?
Well, I think it would be possible. I mean, you have to start with the premise that you have to try to limit the number of persons that enter the U.S. illegally. That has to be the first step. So you have to have more effective border security. You have to have better systems to keep persons who enter legally from overstaying their status and becoming illegal. You have to then, once you have a more secure entry system and better controls, seems to me then you definitely have to have a workplace enforcement system that's driven by bioidentifiers. Interior enforcement doesn't work. For instance, the law that Arizona passed and, of course, was just found unconstitutional, it doesn't really work because and it never has, because you can't basically formulate reasonable suspicion to believe who's in the U.S. illegally, which would then arguably give you a right to question that person, a reasonable suspicion to believe that they're an alien unlawfully present in the U.S. So you really can't do that without, without using racial appearance as the primary factor. So that's never going to work. So really, your only shots at this are, border enforcement, a legal immigration system that allows a larger number of people to come into the country to work legally, and workplace enforcement. I think you need those three things combined.
It sounds like you've just read off the litany of things that most people say we need for comprehensive immigration reform.
It's certainly a number of those pieces.
Yeah. Thank you. I appreciate all of your testimony, and we'll probably have you back again soon.
Thank you all for being here. I appreciate you taking the recess with us. We did do 2 votes, and, the world's still turning. Thank you all so much. This meeting is adjourned.
So I know, very nice to meet you.
Likewise.
I know Lynn got your